Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner. I'm the one who pioneered this particular niche area of the law in California, and I'm the one that created and taught the systems that the three other biggest law firms in this state that represent homeowners in disputes with their HOAs currently utilize. With me today is Senior Associate at my law firm, MBK Chapman, Sam Kill. Sam?
Hello, Mike. Great to be with you.
I appreciate you being here again. Thank you so much. Today, we're going to talk about one thing, power. Mm-hmm. And specifically why HOAs hold so much power in comparison with a regular homeowner. Mm-hmm. Okay? And what the regular homeowner can do to try to even the playing field. And that's the focus today. Now, how did this come about? Another one of our listeners, and I thank all of my listeners for considering this podcast is only 3 weeks old at this point. We're doing really well, and I'm so proud of that fact.
A lot of traction, a lot of support.
I'm very happy about that, and I appreciate it. But we get lots of emails from listeners, which is great. And one of the listeners recently brought up that she had listened to a podcast by another attorney in this field in Orange County, who was talking about some of the issues we're going to talk about today, the power differential. And so I was intrigued, so I went and I watched part of the episode. And what surprised me is that attorney got some stuff pretty wrong. And I want to set the record straight, okay? This person's contention in the video, at least in part, was that HOAs had unbalanced power as compared to homeowners because people will often leave that power unchecked. In other words, if they don't check it, then they have that power. Yeah. And the second reason he attributed was that ambiguities and so either old or ambiguous governing documents, that couldn't be further from the truth. Yeah. I will tell you that ambiguous or old governing documents have almost nothing to do with any power imbalance between the board and homeowners. It's almost irrelevant because the law is all that's relevant, okay? You don't derive power from exercising law illegally or exercising power illegally. You derive power from what the law allows you to do. That's where power is. So I was floored. It's just wrong, okay? And it really doesn't have anything to do with unchecked power. There are really three big reasons why HOAs have disproportionate amount of power, and we're going to talk about them today. But then after we talk about them, I'm going to give you 7 tips to even the playing field. Okay, but what are those 3 things? 1, they are using your money against you. You've got to spend your money to hire a lawyer if things aren't going well, and that's out of your pocket. You're also paying your regular dues and any special assessments that happen to come along to the HOA. The HOA, the board, is using all your neighbors and your money against you if you're the one they're fighting, okay? That's a huge power imbalance right there. They also have insurance. Your insurance isn't going to cover prosecution of a lawsuit against your HOA. But their insurance will, if you go after them, their insurance will cover that, especially their D&O coverage, directors and officers coverage, right?
Exactly.
So that's number 1. Number 2, so they use your money against you. Number 2, a very powerful legal doctrine called the business judgment rule. And I'm going to go into detail with that and tell you everything that you need to know about it. And 3, they're the ones that control the enforcement procedures against homeowners, not vice versa. You don't get to cite the board to a hearing and then fine the board or board members for doing anything wrong. It's a one-way street. That's the purpose that's the basis of the power structure. And you'll notice all 3 of those are given to HOAs by virtue of the law. Outdated documents or ambiguous documents are not going to ever give them a power imbalance. Because if you take them to court, you'll be able to show that and the ambiguous document won't be interpreted against you. It's just, what that is it's a very simplistic and non-nuanced view, and it's reductivist, but it's not helpful. And I want to be helpful. So I'm going to set that record straight. Let's start with, So let me kind of walk through the rest of the episode. So we're going to go into just because it is an imbalance doesn't mean that homeowners don't have tools to level that playing field. They do, and they need to exercise them. And that might have been what this individual was trying to say when he talked about power unchecked. But he was talking about it being a source of the unbalance, and it's not. Right. What it is it's the solution to the imbalance, and if you don't use it, you don't solve it. That's what I'm clarifying, right? Make sense?
That's my understanding. Yeah.
Okay. Now, what we're going to talk about things that most attorneys miss about how the system is stacked. Okay, and we talked the 3. I give you the 3. That's the stacking. And then I'm going to give you 7 effective tools to level that playing field as best as possible. Okay? And then we'll also talk about, what it takes to fight. Okay? We're going to talk about money and expectations because those are the 2 things that you need to manage. Yeah. Let's start with the real reasons that HOAs have a lot of power. Okay? Number 1, we talked about this. They're using your money against you. What does that mean?
Well, they have the resources. They control the purse, right? They can go to legal counsel and get all the opinions, recommendations they need.
Paid for
the
100 of you or the 200 of you. How many people?
They can retain, qualified consultants. They control the narrative and the information. They don't necessarily have an obligation, unless really pressed, to share those with you. They control the vendors. They control who to select as vendors, right?
Correct. People that are yes men and that'll kowtow to them.
And that typically can be intimidating because if you're relying on even a vague reference to, well, we had so and so come out and look at it. And
let's limit it to just the purse because I don't want to go too far afield because I want to keep this under 30 minutes if we can today.
Absolutely.
So they control the purse. Okay, that means that they're spending for everything they buy, whether it's vendors, lawyers, or whatever, they are using all of your money pooled together over time in bank accounts, as opposed to you funding your own thing, in addition to funding your portion of their thing. That's an imbalance right off the bat.
It is.
If they've got a money in the bank that is the add up over time of lots of people's money. The bigger the HOA, the bigger that bank account's going to be. Yeah. Okay, that is important, and money talks. Right. So that's number 1. Okay. Now, let's talk about the business judgment rule, okay, because that's a biggie. The business judgment rule is it is not a difficult doctrine to understand, but it's kind of abstract, okay? And its creation and what it exists for made sense for why it was created, okay? So let's talk about the past. Real quick, though, the business judgment rule is very, very, on a very basic level, is the assumption that the courts will give or make about a board of directors that basically says this board knows more about how to run its business, how to do its day-to-day thing than I do. And I'm not going to interfere with that process, that corporate process, unless I have good grounds to do so, okay? On a very simplified level, it's this deference that's built into the law and called the business BJR, the business judgment rule. It's this automated deference to these people that they know what they're doing. That deference is powerful. And here's why it came into being, okay? Well before the Davis-Sterling Act and well before we had HOAs, we had corporations. Now, I start a company. And by the end of 2 years, I have 100 employees, and I'm producing widgets, and I am the best widget maker in the field, right? The court granted business judgment rule or deference to myself and the board because it expected us to not only understand market forces, who our competition is, but that I knew better than the court about how to manufacture my product and how to sell my product. It makes sense in a private for-profit business. The business judgment rule makes a lot of sense. You don't want some judge who may not have ever, might have left law school, clerked for a judge, worked as a lawyer, and then became a judge and never actually owned a business to be making decisions about how you ought to best run your business, right? So this deference was built into the law, into the corporations code that said, we need to take a step back. This guy here this gal here started this business. She knows her business better than we do. So absent certain circumstances, we're going to defer to her when it comes to those decisions. That's the business judgment rule. And then you get HOAs, nonprofit corporations, the Davis Sterling Act, and no change was made to what the business judgment rule was. It's just applied and adopted as if it was a regular corporation. And it's not. These are lay people. They are volunteers. They aren't paid. These directors and officers who sit on the board are your plumbers, your lawyer, your doctor, your teacher, you're unemployed or you're retired. It's whoever gets elected. They have no particular knowledge about what's the product. The product is running these homes, right? This community. Yeah. They don't have any particular knowledge over anybody else in the world about how to do that. None at all. Okay? When I am the president of a for-profit company and I'm making a profit, I'm actually making money, there's a very good chance I know what I'm talking about when it comes to how to sell my product and how to make my product the best way possible. But that's not the case with lay people who are elected to the board of their nonprofit HOAs. It just isn't. So you've got, I would say the majority of board members have no idea what the governing documents say. I doubt they've ever sat down and read them. And if they did, very few of them would actually understand them because they're not written well on average. They're written very poorly. The point is we give this deference to these boards as if they were boards of real companies that were, if they didn't perform, they went out of business. Right. And that's not what's happening. There's a big mistake in my opinion. It's a big matzo ball hanging out in the law. Okay? But that difference, that business judgment rule is a source of tremendous power for this HOA because to get over it, what do I got to show? Gross.
Yeah, you got to show gross negligence, breach of some kind of fiduciary duty, and that they acted unreasonably and in bad faith.
Beyond just unreasonable, bad faith.
Bad faith. So
or fraudulently.
To illustrate by example is, let's say they had a consultant's opinion and recommendation. Let's say a structural engineer that this feature or this element is on the verge of collapse, and they completely entirely ignore that.
They say, well.
And substitute their own opinion
and
deliberations for that of an expert.
Right.
That would qualify as a breach.
It would be. So in other words, it's not all. There's another doctrine in the law. We're not going to get into it more than 30 seconds, but there's another doctrine in the law that shields directors from liability if they reasonably rely on an expert or a consultant, a lawyer, an engineer, an architect, whatever it is, and that person that they relied on was just dead wrong and it ended up causing damage. That board member is not going to be held liable for that because they relied on, they went and did the right thing. They don't have expertise, so they went and got somebody that did, and that person was wrong. I have no problem with that. That's great. I think they should be protected from that because I want my board members to rely on qualified, licensed experts. Right. So if it's a legal issue, I want the board to rely on the lawyer. And if the lawyer screws up and is wrong, I don't want individual board members being held liable. The board may be, but not individual board members personally liable. They should be protected, and they are. That's a good thing. The business judgment rule was this flexibility deference given to people by virtue of their position and nothing else. That's not right. And, yes, it's true. The exceptions to the business judgment rule are gross negligence or a malfeasance, okay, fraud, breach of fiduciary duty, other intentional acts, or even acting outside the course and scope of your role on the board, okay? If you act unilaterally and outside the normal scope, then that also, you don't get the automatic deference.
Or self-dealing, yeah.
Right. Well, that's fiduciary breach. Right. But the problem with that is those are not as easy to prove. It takes time to prove those. We can prove them, but it takes evidence. I'd rather have the business judgment rule softened considerably when it comes to HOAs. That alone would even the playing field tremendously. Just that one thing. Yeah. I'm not saying get rid of it. I don't want individual board members to be scared and looking over their shoulder every time they make a decision to get sued. That's not what I want. That would be a disaster. What I want is there to be a recognition of reality that this is not the president of IBM or the president of Ford or Chrysler. Yeah. This is Mrs. Robinson, 6th grade teacher at, Harvey Mudd Middle School, okay? That's what I want. I want there to be a softening of that business judgment rule. Now, The money thing, you're never going to change that. That's always going to be an imbalance. You can't change that. It's impossible. And then that third one we talked about, court order, you're not going to change that one either, right? Mm-hmm. You're not going to change that. What was the other one?
Insurance.
Yeah, you're not going to change that. Okay.
Yeah. Mm-hmm.
So now let's talk about, but the business judgment rule, that is a big one. And there is something that can be done. I don't think it will happen, but it could. And if I had my way, it would. Mm-hmm. And it would bring some balance right back. But in the absence of that change, or in the recognition that the business judgment rule exists as it does, let's get our homeowner 7 tools.
Okay.
These 7 tools help even the playing field. Well, really it's 6, and the 7th tool is less a tool to even the playing field and more a tool on how to use it to even the playing field. Okay. So the first one I call tool number 1, and it's his favorite one. I'm going to let him take it.
Okay. Well, this is prepare yourself. Document
everything. Use the same words you always use.
Use written correspondence. When you make a demand request on the board, do so where it's clearly articulated. Keep it cordial. Keep it respectful. And treat, and Mike's going to get into this, but treat any written communication or communications in general as if it will ultimately be presented to a judge.
Right. But first things first. Mm-hmm. You want to preserve everything. First of all, you want to keep a record. Okay. So we've mentioned before in the past, keep a log.
Right.
Okay. In addition, keep all your emails and text messages. Back up your phone. Don't let those get deleted. If your phone automatically deletes text messages every 30 days, I know some people have that setting, then download them or do something, because if you lose them, you lose them. They're gone forever. Preserving means preserving, so preserve. That's why I prefer email. It's more safe than maybe text messages.
Absolutely.
So preserve. Keep your emails. Keep that log. Take pictures if it's applicable to the situation.
Right.
He was about to embark on a second part of this, document everything.
Yeah.
And that is, and I'll get into this a little later, okay? But that is, assume that every email you write, every text you send is going to be seen at some point in the future by a judge or a jury. Just make that assumption. So keep it professional. Let them look unprofessional and immature and emotional. Keep it very even-tempered. Even if you have every reason to be livid at how you're treated, when you're in writing, you be the one that is sane and rational. Let them lose it. Now, verbally, whatever. Do what you got to do, okay?
Yeah.
But in writing, assume it's going to be seen later. I promise you that does come back to bite them.
And that's especially difficult if they're not responding to you or acting.
And then keep it non-emotional.
Yeah, and you have to follow up repeatedly.
Great. Fourth notice.
Yeah.
Please respond.
Exactly.
This is my 4th email to you. I wrote you first on July 1st, then on July 10th, then on July 15th, and now it's July 18th. Please get back to me and just keep a record in every email. Mm-hmm. Be professional. Don't go, how dare you ignore me? If you do this again, I'm going to blah, blah. Don't do that. Don't do that. Keep it professional and keep it non-emotional. It will pay dividends later, okay? Now, legal tip number 2. Not only do you want to document, but you want to know your governing documents. It is very difficult to win a game if you don't know the rules. So, if you aren't familiar with what part of the CC&Rs or what part of the rules or the architectural guidelines or the bylaws your board is violating, then you can't call them out on it and you can't prove any wrongdoing. You got to know that there's something going on. And I'm not expecting you, for example, with CC&Rs, okay? With rules, they're generally written by lay people, or they're written in more modern English, so they're easy to, rules are technically, or tend to be very easy to understand, but CC&Rs aren't, because they're written by lawyers, and a lot of lawyers are just really terrible writers, and they write in this jargon that they think makes them sound smart, and it doesn't. It's crud. But the point is, that's how they've been taught, so that's what they do, and they don't think for themselves. So they write these CC&Rs, which are very hard to understand. I'm not expecting you to understand them. And I'm not expecting you to read the whole thing. You don't have to read all the parts about the gas and utility rights, unless that's an issue. You don't have to read the parts about, preserving the rights of the lenders, right? Or of Fannie Mae and Freddie Mac. You don't have to read the parts about water use or water rights if it's applicable. But you do want to look at the parts that say, here's what the things you can't do with your property, and here's the things you can do with your property. Or the parts that say, here are the powers the HOA board has, and here are the powers they don't have. Those things you want to be able to read. Here are your parking, or here's the cars you're not allowed to have, or the vehicles. That stuff that affects your lives. That's what you want to look at. So know your governing documents, okay? How are fines and penalties calculated? How much are they? That's the part you want to know. Architectural guidelines. Those are going to be like the rules. They're going to tend to be written in more modern English, right? Yeah. Those are easier to understand, but you want to know what they say before you start building something, before you submit your plans. You know, if you know that you have to honor a 10-foot setback, then don't plant your garden greenhouse within the 10-foot setback. Mm-hmm. Try to plan ahead, okay? So you got to know what your governing documents say, okay? Don't assume, by the way, that the board knows what they say. In fact, I'd assume the opposite. But you need to know, okay?
Absolutely. Okay,
legal tool number 3, and this is the part where he was jumping ahead to and that I jumped ahead to. Be strategic in your informal contact with the board, okay? Short, respectful, down-to-the-point emails or communications are the order of the day. Don't throw everything in the kitchen sink into an email, okay? If there's an issue regarding a leak, then the emails on that issue should deal with just that leak. Don't start throwing in stuff about how, and this wasn't on the agenda and you didn't do this. And
right.
You lose the forest through the trees when you do that.
Absolutely.
Okay? Be strategic in your communications. If you want to talk about meetings and documents and the leak, then do 3 separate emails.
Right.
But keep them separate. Strategic thinking. You want to be able to organize your documents and your subject lines. That's another thing. Don't allow ongoing subject lines where you wrote something, they replied, you replied, they replied, and then a month down the line, you're on completely different topics, but the subject line is still the same subject line from that day one. Don't do that. Start new threads so that the subject lines are easy to track in your email and you'll be able to follow the conversation or the issues without having to open every email and read them all over again, which is another reason why you don't want to throw everything in. It's very hard to read.
Yeah, I mean, in addition to not convoluting it, one addition briefly, try not to be incessant. If it's incessant with a barrage of emails, let's say 100 within a 3 days.
What do you mean by that?
Let's say if you're flooding them with, let's say, something unreasonable, 60 to 100 emails within 3 days.
Yeah, that's too much.
That's too much.
Okay.
You know, keep it reasonable.
Especially when, and we see this a lot, guys. We see this all the time. They send the same thing. They just mix the words up a little bit.
Yeah.
But it's the same stuff. You don't need to do that. One is good. A follow-up when you've been ignored sufficiently. Mm-hmm. The reason you do those follow-ups, like I was saying, 2nd attempt, 3rd attempt, 4th attempt, is because it looks beautiful when we are crafting your story, either in an ADR demand or in a mediation brief or in a complaint, a lawsuit, where we can bullet point the undisputed facts. That is, these are facts that defendant cannot reasonably dispute. On this date, plaintiff wrote to them demanding this. Mm-hmm. It was ignored. Yeah. Plaintiff followed up on this date. Follow-up was ignored. Plaintiff followed up on this date. Follow-up was ignored. Do you know how good that sounds to a trier of fact in building your case about the wrongdoing of this HOA? It sounds great. But 25 emails, 30 emails in 2 days, not reasonable. And there's no need for it. Be strategic in your communications. And this is where we were going to talk about being careful about how you say something or what you say because you want to assume that a judge is going to read it. This is where I would have wanted to put that in. I didn't.
Got it. Okay.
So we jumped ahead. We apologize for that. But in last piece of advice, although you might want this, and we have hundreds of people ask us for this over the years, you're never going to get this because it's emotional and it's not real. And that is, I demand a written apology.
Oh, yeah.
You're not going to get an apology.
Right.
Even if they're dead wrong and they treated you like garbage, what's really important is that you get what you were entitled to, not the apology to assuage your feelings.
Right.
Let's get rid of that off the bat. Don't send emails to these people demanding an apology. You're never going to get one, and you're not really entitled to one. The law doesn't require them to give you one. Even if they're wrong, the law might say write them a check, but it's not going to say write them a check and issue a written apology. So let's not ask. Let's just dispense with that, okay? Mm-hmm. That's emotional. I know it feels good, but it's not going to advance your cause at all. Unless your only issue is purely emotional, in which case maybe the dispute isn't real, okay? Am I being real enough for that?
I think so.
Okay.
Yeah.
Legal tool 4, demand IDR. Mm-hmm. Only demand internal dispute resolution when you feel it's going to be fruitful. If you have been a constant thorn in the side of the board because you're the one that makes them see all the stuff they do wrong, which is perfectly okay, you should do that, then maybe they're so emotional about you or they have such harsh feelings about you that IDR with them isn't going to help. That's probably true. Go with your gut on that. But if you think it could help, help. So what's IDR? Internal Dispute Resolution. Well, first of all, it's free. And second of all, the Davis-Sterling Act requires HOAs to engage in IDR if a homeowner requests it in writing. So request it in writing if you feel it'll be helpful. And in IDR, it's your chance to sit down either in person or by phone or Zoom with one or more members of the board to talk out your difference, whatever it is that's, that you have a problem with or that they've done that violates the law or your rights or whatever it is. That's the chance. Now you can see why it wouldn't be any good to talk to somebody when you know that they despise you and they have no interest in actually working it out, then don't bother. Right. But if you think it could help, it certainly could. It could help. Mm-hmm. It couldn't hurt.
Right.
So do it. You don't get a lawyer. They don't get a lawyer. There's no money. They can't charge you a fee for their time. It's free. And they have to engage. Now, if they refuse a written request to engage, you just notate that in the little records you keep, okay, in your documents, and you make sure you tell us when you come see us, because we will hold them accountable for violating the law by refusing IDR.
Right.
You can refuse to do it, but they can't, okay? Now, if you go to IDR, great, do what you can. If you work it out, fantastic, everybody wins. If you don't work it out, then we'll get to what you do next in the next tip. Now, often, remember I said this a minute ago, and you tell me if I'm wrong if you've seen this. I've seen it. Tell me if you have. Okay. Either the HOA suggests IDR when a homeowner has a dispute and is really upset about something, or the homeowner brings it up, and then decides, no, I don't want to do it. Okay. I have seen many HOAs imply very strongly that IDR is required. That we have a written IDR policy, and you must engage in IDR before you can go and get a lawyer. That is, have you seen that?
I have seen it.
Okay. Yeah. That is hogwash. It is untrue.
Right.
It is wrong. The HOA can't decide to refuse IDR if requested in writing by a homeowner. But a homeowner can refuse IDR if requested in writing by the board, and a homeowner can choose not to bother with IDR at all and just skip it and go directly to the lawyer and say, what should we do, lawyer? So don't let a board convince you to engage in IDR if you've already made the decision that you don't want to. They are wrong, and they do this frequently because it's cheaper. They don't have to hire anybody. And because they know it's a waste of your time, and they're trying to when they know they've done something illegal or wrong, they want to discourage you. The best way to discourage people is to have them waste their time, okay? And run them through the ringer, and that's what they want to do. So if you've decided that IDR is not going to be helpful, you made the decision for a reason. You know yourself and them better than I do. I'm going to trust that you had a reason. Well, they know the reason too, okay? So they're going to try often to dissuade you from that by trying to convince you that you have to do IDR. No, that's wrong. It's just wrong.
The other reason they attempt to do that, the ones that engage in that wrongfulness, is they want to document their alleged or purported good faith or investigative duty, et cetera.
And so my response to them, let's say, would be, let's say it's them requesting it. I appreciate the fact that you want to try to resolve this dispute with IDR, but because of our history and the fact that you have already responded to me in certain ways in the past, or I've already made this request numerous times and no movement has occurred, I don't believe it would be a productive use of either of our times, and therefore I'm going to decline, but thank you. So what you did there was you didn't allow them to reshape the narrative by looking reasonable, because you equally reasonably, but very professionally explained why, hey, it's a waste of time because you're just going to waste everybody's time, so we're not going to do it. That's what you said, but you said it in a very eloquent and nice way. And that's how you'd want to phrase that. Right. You don't want to go, screw you, you're a waste of time, you're just a crook, you're just a fraud, blah, 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 because that's going to just come back on you later. That doesn't look good. It makes them look professional. We don't want them to look professional when they're in the wrong. We want them to look like they're in the wrong. So help us help you. So IDR fails, or you decide IDR is not for you. Legal tip number, are we on 5? I think we're on 5. Serve a proper ADR demand. So IDR is internal dispute resolution. ADR is alternative dispute resolution. Now, in the parlance of litigation and civil law, you have criminal law, civil law, right? ADR means more than one thing. ADR can mean something called arbitration, or it can mean something called mediation. Arbitration is akin to going to court, okay? It's just a private judge or a private party resolving a dispute. But in arbitration, binding or not, you have a judge or judges who are evaluating evidence. There's people that are being sworn to testify under penalty of perjury, and there's a decision made that can be turned into a judgment in the court, okay? That's arbitration. Mediation is a fancy word for formal settlement discussions. It's not binding. There's no evidence evaluated. There's no testimony being taken. There's nobody under any kind of oath. It's simply you putting together a little package of why you think you're right, submitting it to a neutral, who then his or her job is to sit down with the parties, usually in separate rooms, but to sit down and try to foster a settlement. That's all it is. Parties on either side during a mediation can walk out if they don't think it's being fruitful. You can't just walk out of an arbitration. You could lose and then get a decision against you. So that's ADR. But when we use ADR in the context of the Davis-Sterling Act, specifically with HOAs, ADR, as we're using it, means one thing: mediation. That's all it means. Now, ADR under the Davis-Sterling Act is required in situation where a homeowner is seeking to enforce the governing documents and either of the following are true. They're only suing for injunctive relief or deck relief, or they're doing one of those two things or both in conjunction with damages over $12,500. In those three, or I guess that's three, it's not three conditions, it's three circumstances, I guess, right? Mm-hmm. Yeah. Only if you meet those qualifications is ADR required by law as a hoop that you're supposed to jump through before you can go right to a lawsuit. That being said, because of the part of the very system, the pioneering system that I created involves using Davis-Sterling's ADR as a mechanism to drive 98 to 99% of our clients through. Because with the system that I created, we were able to get the percentages of cases settled at ADR much higher than 50%, which means you're more likely than not to settle a case without having to go to litigation, which could take years and 6 figures. We're talking $10,000, $12,000, $13,000 at tops, maybe, right? Or less, versus hundreds of thousands. And so we want almost every case to go through that, because the system I have put into place, and many other law firms that their partners that actually worked for me have learned that system and are doing it in their own law firms, including that individual that we were talking about at the beginning with the YouTube channel. But anyway, that is a much better use of money and time. So we push everybody into that. But it is required, at least in the cases. So if you're seeking just injunctive relief or deck relief, or you're seeking that in conjunction with damages for money of more than $12,500, then it's required. Other than that, it's not required. If it's not an enforcement action, for example, okay, if it's a breach of fiduciary duty and nothing else, it technically wouldn't be required, but we'd still want to do it.
Right.
Okay.
Absolutely.
So ADR, in terms of what we're talking about, is mediation. You've done hundreds of mediations with our law firm and elsewhere. Walk me through, if you can do it in a minute or less, walk me through how informal a mediation is.
Well, it's largely conversational the day of the mediation. So like you alluded to, it's it's either in person, but largely virtually these days. So
nowadays, since COVID, right?
The parties, respective parties, whether it's 2 or 3, they're placed in different breakout rooms, and we typically have 4 hours, and the mediator, having read the parties' respective confidential mediation brief.
Confidential meaning what?
Confidential meaning you don't share it with the counterparties or opposing parties.
The only person that reads our mediation brief and theirs is the mediator.
Is the mediator, is the neutral, and who's typically either a former judge or a seasoned attorney practitioner.
We usually demand former judges, though.
Correct. And they're very good in terms of engaging legal counsel, but with legal counsel's permission, the client directly, hey, what's going on with you? Please tell me a brief
Tell me your story. Tell me your
story. And they're typically the ones that are on our preferred list of mediating with. They are very good at this. They're very tactful, respectful, courteous.
Well, we pick good ones.
And they also are cognitively capable of recalling a lot of the details from the mediation briefs and conveying and relaying that to the counterparties.
Well, they don't relate the things in the confidential brief other than what we've told them that they can
undisputed
convey.
Facts, the claims,
right?
Basically,
Exactly.
Right. So in conclusion, the two large functions that they perform is one, they evaluate, but they don't necessarily make a ruling on it like you would in.
Just to cut you short, because we're going to run out. Basically, it's very informal. It's very conversational.
Right.
There's no pressure. You don't have to prepare. The homeowner doesn't have to prepare for mediation. No. The homeowner just has to understand what the process is. And us as lawyers, we send an email out before mediation kind of explaining what you can expect. But it's a very simple process. Right. It's very friendly. You're not being grilled. You're not being questioned. And by the way, if you don't want to, even if it almost never happens, but especially if you don't want it to, you won't see or talk to the other side at all. You'll only speak with the mediator and us, your lawyer. Right. You won't speak with them or their lawyer. Neither the twain shall meet. That's how we like it. Mm-hmm. And it reduces, it takes away all the anxiety that people often, they think they're going to have to face these people. No, you don't. It's very simple. Now, let's talk about this ADR, okay? Under the Davis-Sterling Act, because it is, in those cases I discussed, is required in many cases, there's a statute that discusses what has to be in an ADR demand in order for it to be valid. And then there are a bunch of statutory timelines that kick in. I've said this before, and I'm going to say it again here. This is one of those situations where we strongly recommend that homeowners who have gotten to the stage where they need ADR, okay, do not do this themselves. They come to us or they come to another qualified law firm. But since there aren't really many, I would say there aren't any other more qualified law firms, I say come to us. But come to MBK Chapman, okay? We'll do the ADR demand for you. And the reason we want to do them is because I've had clients do their own and then they hire us after the fact. Sometimes after they've already gone to mediation on their own and that was a debacle or a joke, or they hire us before the mediation date but after the ADR demand. Here's the problem with it. Number one, you fail to properly cite the statute, which would invalidate it technically anyway. And the reason there are these requirements is there's actually a consequence or penalty for not following. I'll point out another little error that this other attorney made in this video that I saw that I was directed to by a listener. This gentleman mistakenly said that if you refuse to go to ADR when it was required and the other side doesn't demur or do anything and it's actually able to go forward, that you lose your right to attorney's fees if you prevail. That's not what the statute says. It never has. That is a common misunderstanding with a lot of lawyers that actually don't have a nuanced understanding of the Davis-Sterling Act. That's just a fact. Mm-hmm. What the statute says is that in deciding how much to award the prevailing party in fees, if that prevailing party was one that skipped the ADR process when it was required, the judge can take that failure into account in deciding how much to award. Not whether to award, how much to award. That's a big but nuanced difference. But that is a massive consequence because he could cut your fees by 50%, 75%. We're talking a lot of cheddar. So you want to, if it's required, you want to do it, okay? Which is why 99% of the time HOAs will accept our demand. Yeah. Even if they know there's no chance we're going to capitulate or this is going to settle. Right. Or they think there's no way he's going to make, or he or she's going to make a fair offer to us. It doesn't matter. They know they have to jump through that hoop because they don't want to risk it, okay? Which is a powerful tool, by the way. But failing to properly cite the statute might take it out of, right? Even, of course, if you end up at mediation, it won't matter because form over substance doesn't rule. So you'll probably be fine with that. But mischaracterizing the legal claims that you have, either you miss out on a bunch of them or you don't talk about several of the issues. Keep in mind, at the mediation, the only things that can be discussed, technically, The only things that are up for mediation are the things that are set forth in the correspondence. So if you don't raise certain issues, or the HOA in their response, let's say accepting it, don't raise some of the other issues they want to add to that list, and if it's not in those letters, it can't be discussed. Okay? It doesn't fall under the ADR rubric. That's problematic because I don't want to start all over again. Okay, when you come to us, you could ignore some of your rights. Some of these timelines that are put into place were put into place to protect homeowners, not the HOA, to protect the homeowner. Okay, we have a 30-day limit on how long they have to respond, and then there was a 90-day limit on when the hearing has to be completed. Of course, those can be extended by mutual consent, and that's never a problem. You can extend it a year, 6 months, as long as you want. But if you aren't aware of those details and you don't understand how to hold their feet to the fire, you could be sitting on this for 6, 8, 10 months and have gotten nowhere. If you're adamant about your rights and the timeline, we'll make sure one way or another we're done within 4 months, because that's the statutory minimum. Okay, maximum, right?
Right.
Could be less. They could we could serve our demand letter, and on day 5 they accept it, and then it's 90 days from that date. So really it's 3 months and 5 days. But the point is, we know how to leverage those statutory dates. Homeowners don't. Come to us. Let us do it. We'll take care of it for you. Because if you risk it yourself, you're going to make my job harder. Okay? You just will. Now, again, even though ADR in some cases isn't going to be legally required, we almost always recommend doing it. And we encourage our clients to participate, even if they know it's not going to work. There's reasons to do it. We've been able to work miracles, and a good mediator can work miracles. With a good lawyer like us, can work miracles in getting cases that you thought had no chance of settlement. Or you might have 13, 14 issues that are massive, and we could settle 6 of them. That's 6 less to litigate later if you're of the mind to litigate. In other words, help us help you. Okay? Legal tool number 6, understand what ADR really requires. Okay, we've already talked about that one. That's about enforcing governing documents. Okay, that's about, I guess we jumped ahead of this too. I'm so excited I ended up jumping ahead. This was supposed to be its own legal tool, which was understand when it's required and when it's not. Right? Yeah. So we jumped ahead. So I mixed 2 other ones. I apologize. But it was supposed to be the one about if it's an enforcement action and injunctive or declaratory relief only, or in conjunction with damages of over 12.5. So you want to know, because again, there's consequences for skipping. And that was the reasoning there. Okay. Last tool. And that's about managing expectations regarding both expectations for outcome and expectations for money. And then I'm going to close. The money one is real simple. Litigation, that is eventually if you go to court, file a lawsuit, that's litigation, is monumentally expensive. Now, it's true, a case could settle, you spend 10 grand, get a complaint filed and served, and a case could settle right away. But most cases don't settle right away. If they're going to settle, they settle before it, or they settle after discovery. So you're going to spend, at a minimum, tens of thousands of dollars, and you could spend, some cases, $200,000, $300,000, $150,000, $400,000. It's all over the map. Depends if there's experts involved. It depends on a lot of factors. It's extremely expensive. So it's to be avoided if possible, okay? Whereas the ADR pre-litigation scenario, which is I term pre-litigation, I broke my firm up into litigation and pre-litigation, and that was in that steerage of people into these ADRs, is the part of the system I developed, is by orders of magnitude less expensive. And here's the amazing thing that I like to tell clients. We can negotiate things at ADR, so at mediation, pre-lawsuit mediation, not post-lawsuit mediation. That's different. We can negotiate things at pre-lawsuit mediation that you are not entitled to under the law. In other words, that they're not remedies that we could get you if we end up suing. It's not one of the things a court could order as damages, okay? But we can often get them for you. I'll give you one example, okay? Unless a person is sitting on a board in violation of the law, for example, they don't live in the community, okay, and they're on the board of directors, that's illegal. Unless you're suing for that reason to get them off, a judge is almost never going to offer a remedy of removing a director from the board. They're never going to overrule the democratic process of what the people in that community voted for. But we've been able to negotiate somebody resigning from the board and promising not to run again for a certain period of time. We've been able to negotiate that. And if they voluntarily negotiate that and it's built into a settlement, it is enforceable. So stuff like that.
Yeah.
We can get things sometimes, capitulations, that we aren't necessarily entitled to if we have to file a lawsuit. So on that basis alone, it's always worth trying. It's also a lot easier before a lawsuit to get settlement because the amount of monies involved aren't excessive, right? So people are more willing to be reasonable.
Right.
So that's why we do that. So if you come in making demands for, I don't care what it's going to cost, I want this and that, sit back and make realistic budget recommendations. Do you really want to spend $50, $100, $200,000? Or maybe it'd be more willing to spend, 10 or 12 grand and see where you get, right? Okay.
Yeah.
Now let's manage expectations. How often, Sam, do you get somebody come into our office and ask for $1 million in emotional distress damages?
I would say about once a week.
Yeah. I want $1 million. For some reason, that's the number. I want $1 million.
Yeah.
And with all respect to those people, there's no doubt they've been injured emotionally and hurt. I get that. But their emotional distress isn't, even if it exists as a remedy in the law under their case scenario, which it most frequently doesn't, their emotional distress damages aren't going to be even a fraction of that. It's going to be an infinitesimal fraction of it. Because the law doesn't award what you feel like you want.
Right.
The law has its own calculations, okay? Our job is to manage those expectations, and the clients come in with them. Our job is to educate the clients as to what the real remedies available are and what we think is realistic based on the facts, and then to make an offer from there. That's kind of where we go. So do me a favor and just remember that. Let us come to us with all of your expectations, but then let us guide you as to what's realistic, okay?
Yeah.
Be open to letting us guide you onto what's realistic. And if you can follow those 7 tips, you'll have gone a long way toward evening up the power differential between an HOA and the board. I'm Michael Kushner. This has been HOA Hell. If you like this episode, please hit the like button and please subscribe to the channel if you haven't already done so. If you have a question or a comment, we'd love to hear from you. And until next time, have a wonderful day.